State and public offices have until the end of the year to file their wealth declaration forms for the status of their wealth in the last 2 years.
The exercise is expected to help track the source of wealth accumulated by public servants and to ascertain that it wasn't acquired illegally.
But as NTV's Brenda Wanga reports, the exercise has been criticized for doing little to deter those who thrive in graft.
The IEBC is set to engage in another round of wealth declaration targeting serving state and public officers as well as those recently elected to office.
We expect compliance to be even much better.
But even as the anti-graft body expresses optimism that more will fulfill this legal and constitutional requirement, there are those who are casting aspersions on the efficacy of the exercise that was mooted as a silver bullet to the endemic corruption problem in the country.
But within the context of our political setup, I think what has happened is that because of the illicit nature that accompanies the way we run our public offices and corruption, it means that a lot of people don't want to declare their wealth because it obviously will show that they cannot account for that wealth.
Wealth declaration is a requirement of law under the Public Officers and Ethics Act. Its main aim is to encourage integrity in the public sector. But has it been serving that purpose?
So far, we have not seen any premium out of it. And I think if you ask most of our public servants, they will tell you that this is a mere formality, a ritual that is meaningless. And I do know that there are some who even ridicule that approach.
We focus a lot on financial investigations. And when you are looking or investigating an individual in terms of one's worth, the wealth declaration becomes a very important document to look at.
Indeed, the enthusiasm with which the public embraced the inaugural wealth declaration has been tampered down with the non-disclosure of the contents of the said forms.
You want to see the intention of the drafters of the law when you consider that the offense of disclosing the contents of a person's wealth declaration attracts a higher penalty than the failure to file a wealth declaration itself. So that in a sense you see a law that was undermined at the point of birth.
The IEBC says although the lack of public disclosure of the contents of the form is a hindrance to the fight against graft, the fact that the forms are available is a win in itself.
While the IEBC maintains that wealth declaration remains a critical tool in the fight against graft, the same commission is now asking Parliament to legislate and make it possible for the wealth declaration forms to be made public, as this move, it says, will not only aid in its investigations but also allow the public to question the wealth that has been declared by the state and public officers.
Perhaps if the law was amended to allow for these documents to be public, it would help, because any person can actually investigate or verify what one owns.
Those wealth declarations are filed. First of all, they are filed in hard copy, and they are just filed away, perhaps put in a dark room where they are not, nobody goes back to them to look at them. And we have also adopted a very opaque, non-transparent way of dealing with them.
The exercise is expected to be carried out every 2 years, both at the national and county government levels. And while opinion is divided on its place in the anti-graft war, the IEBC says it is seeking ways of improving the efficacy of both wealth declaration and the attendant lifestyle audit as powerful tools in the war against graft. Brenda Wanga, NTV.
The Supreme Court has given petitioners who successfully filed their case until Sunday midday to serve the respondents, who in turn have until Monday 5 p.m. to respond to the petitions.
The President of the Court, Justice David Maraga, in his directive also says the petitioners must file their written submissions and responses by 5 p.m. on Monday.
The directives coming only a day after the IEBC intimated that they will have new lawyers on its panel, as those deemed to have underperformed stay away.
Mijungu with the details.
The directives released this afternoon by the President of the Supreme Court, David Maraga, spells out the timelines his court having received the petitions Any party wishing to file an application relating to any of the petitions must do so and serve the applications together with the written submissions by at least noon on Monday. Such applications shall be limited to a maximum of 5 pages. The petitioners, however, have a maximum of 30 pages of written submissions.
Yes, they are.
So far, the court has received 2 petitions challenging the election of President Uhuru Kenyatta and his deputy William Ruto, while 1 petition seeks the court to find NASA and its leaders in violation of the electoral laws. Parties wishing to be admitted as friends of the court have until Monday 5 p.m. to make their applications and file written briefs limited to 5 pages. The petitioners are the Institute of Democratic Governance, John Harun Mwau and Mijungu Mue, together with Halef Khalifa. The court is yet to announce the date for the pre-trial hearing, but going with a strict constitutional timeline to dispense with a presidential petition, it could be on Tuesday, the 14th of next week.
My Lord, the Chief Justice, my lords.
At the same time, Paul Mwite, who represented the IEBC in the last petition, is out of the panel. Mwite, who made most of the submissions on behalf of the electoral body, caused a stir in court when he stated that the custodians of the IEBC servers abroad were still asleep as one of the reasons for non-compliance. The court will later find the IEBC in contempt for not allowing access to their servers.
That the sovereign will of the Kenyan people is captured and can be ascertained by looking at Forms 34As. This Form 34A needs, repeat, in terms of clarity, at the conclusion of the voting.
The other advocate who is out is Professor P.L.O. Lumumba, whose submission that small things should not be considered and wowed the court with his impressive eloquence will not be on the panel.
In response to the petition that is before you this afternoon,
another absentee will be Paul Nyamodi, one of the in-house advocates for the electoral body. His role in the nullified petition was minimal. He, however, is on the role of those advising the IEBC.
The only issue that I wish to now take up, my lord.
The only advocate who still remains is Kamau Karuri. The others are still unknown. In the Harun Mwau petition, it's clear that Ben Musyoki will be the lead advocate. The consolidated petition by Mue and Khalifa will be led by the firm of Harun Dubi, while that of the Institute of Democratic Governance will be led by the firm of Kioko Kilukumi. Ken Mijungu, NTV.